More chairs there.
Thank you, my Lord. I appear together with Madam Mr. Zulu for the applicant in the leave to appeal the second respondent in the court.
And my Lord, I appear on behalf of the former.
My Lord, I appear with Mr. the respondent in the application for him to appeal, who was the applicant in the application.
As I've indicated to I am sympathetic to the application appeal, but unfortunately there seems not to be a little with the application we need to appeal partially to the application. Yes, it's right.
Or either a declaratory order that the interdict granted by Makoba still stands, or alternatively an order reviving the interdict, or alternatively a new interdict. I've also asked for further and alternative relief, and we're arguing that our application also provides grounds for your lordship to, instead of granting our application, to make the interdict part of a condition for leave to appeal in terms of section 125 of the Superior Courts Act, which replaces section 25 of the Supreme Court Act. And with the lordship's permission, I'll hand over the act.
I think the objection, if I understood what Mr. Mokhari said to the chambers, is that the note of motion as of now is formulated. It doesn't put them on notice, doesn't give them time to file it.
Our response to that is that the application is so integrally part of the leave to appeal that there was no need to bring it as a separate application. It's not as if the application was moved from the bar or that they were given a day's notice. The application was brought with reasonable notice given the fact that this application for leave to appeal is being heard on an agreed urgent basis. And although the application made no provision for response times, there has been time for the respondents to put themselves on record as opposing it, or to put in the notice of irregular step. They have done none of this, nor have they mentioned the application in their heads of argument. But just with regard to whether this application requires to be dealt with separately, I'd like to refer your lordship to
seen, but I'm looking at section 17, subsection 5, which, when did this act come into effect?
In
August. But it replaces a provision that existed in the Supreme Court.
In the Supreme Court Act, and although it does provide examples of the conditions, that's not a closed list.
It says basically, any leave to appeal may be granted subject to such conditions as the court concerned may determine, including such and such.
Yes.
Do the real rules deal with this in any way?
Not in particular, my lord. Section 49. Rule 4911 does allow your lordship to make an order regarding
suspending the effect.
But we're saying that this is in some way the corollary of that, because what Rule 4911 and now that's included in Section 18 of the Superior Court Act. What it does is to restore the status quo before the order was granted. So it seeks to keep the parties in the same position that they were before the order that is subject to appeal is granted, not to place anyone in a better position than they were before the appeal was granted. So it's the principle that's...
I'm in agreement with all that. It seems to me that the court would have inherent jurisdiction to grant such an order. It would seem that it would have jurisdiction to grant such an order in terms of Section 7.5. But the question that concerns me is the issue of whether you have followed due process in seeking legal.
If I may refer your lordship to the case which we refer to in our heads of argument and is at page 230 of the main binding authorities, Constantinides versus the Gauteng.
So again, what, page 230?
230. At page 53C of that judgment, which is on page 245. You know what, in this case, the application was heard, and then judgment was handed down on the 9th of March. Counsel then made application for leave to appeal, which was also granted on the 9th of March. And then an application was made from the bar for what was first called an application in terms of, well, an application to stay the dismissal of the application, but the court correctly characterized it as an application for an interdict. And the applicant for leave to appeal then said that they were not ready to, the respondent said that they were not ready to argue this. So the court adjourned for 3 days to allow him to prepare. The same judge heard the matter and then handed down judgment. The judge also refers to an unreported decision of the also on page 245, Anschutz versus the Jockey Club, and describes exactly the same procedure being followed. So, my lord, our submission is that this is an entirely acceptable way of dealing with something which is so integrally part of the main application.
So you could have even just moved it from the bar?
Yes, my lord. And we've been generous to the applicants or respondents by bringing the application on notice.
Thank you. Mr. Mokhari? Mr. Hodis, I'll take it. You've got nothing.
I've got no role to play.
Thank you, my lord. As your lordship correctly pointed out, that I raised certain matters to your lordship in chambers regarding the nature of this application that has been brought by the by freedom under law, which freedom under law purports to set down on the same date that your Lordship set down the application for leave to appeal, which does not even inform us when we must file opposition if we want to oppose, when we must file opposing affidavit if we want to oppose, and which then
When did you receive it, Mr. Mokhari?
we received this application I don't know when it was received. There's no service, but the application is dated the 15th of October 2013. Your Lordship will remember that a directive was issued by Your Lordship even before the South African Police Service filed an application for leave to appeal. That's the first thing. And I don't know if that directive was applicable to the SAPS because at that time...
That directive was simply that I was available today and that we should work out a timetable among yourselves.
Your Lordship...
And that at least get the heads to me before the 18th. That's all the directive was.
Your Lordship did not even know whether SAPS was going to appeal or not. So the directive is issued before 15 days lapses, which are the dates which the party who seek to appeal is given. Then after that directive is issued, the South African Police Service filed an application for leave to appeal exactly on the last day. Immediately thereafter, there is an application that is brought by Freedom Under Law, which is not at all encapsulated in the directive of Your Lordship.
What do you say about the position that they're entitled to bring that application from the bar?
It's an absurdity, my lord.
No, there's authority for it in the case.
It is an absurdity, and I'll inform Your Lordship why it's an absurdity. It is an absurdity because this is an application which relates not to the order which has been granted by Your Lordship. It is an application which relates to an order which was granted by your brother, Makhuwa J. Not at the time when you were hearing your application, by the time when there was an interim interdict that was sought on an urgent basis. So it is completely different.
But we confirm and discharge orders all the time by our colleagues.
Even
Civil
when
Procedure 101.
no, even it is not. Even at the time when Part B was argued, I would like to submit that the procedure is completely irregular. Even at the time when Part B was argued before Your Lordship, Part A was not an issue. I remember very well that Your Lordship wanted to, in fact, deal with Part A.
How are you going to deal with
And
it?
Mr. Malika specifically said that I'm not actually going to ask Your Lordship to deal with it.
Because you don't need to.
That's what they did. So Part A was never at all before Your Lordship. Now, an application which is brought to resuscitate an interim order which was granted by Makhuwa J, first of all, can never be brought before you. It must be an application that is brought in the normal course in terms of the rules and directives of this court. It must be filed with the registrar of the court, and then it must follow the normal process. I've never heard of an application which is a substantive application like this, where such an application, a judge is already chosen, that this application is going to be heard by then yourself as the judge. So that is why I've mentioned that. The application is improper because, first of all, it does not follow the rules of court, but secondly, it purports that it must be heard by Your Lordship without it having been entertained by the Deputy Judge President or the Senior Judge who must allocate motion proceedings. If it was an urgent application, I'll understand. It's not an urgent application, and my learned colleague conceived that it's not an urgent application. It's not a Rule 4911.
Right, let me just ask you, Mr. Mokhari. So the Commissioner is opposed to this interdict staying in place, is that correct?
There is no interdict in place. The interdict lapsed at the time when the Lordship handed down judgment.
Well, there's a difference of opinion about it, all right? Wait a minute, there's a difference of opinion.
Yes.
All right? So, but the Commissioner, if I understand you, does not want to be constrained by such an interdict. Does she want, is it because she wants General Mdluli to go back to work?
No, that is presumptuous, and I'm not going to respond to the question.
Then why?
I'm not going to respond to it because it's presumptuous.
How dare you say that to me?
No, I cannot respond to such a question because it's
How
presumptuous.
dare you say that to me, Mr. Mokhari?
I'm not going to respond to that question.
You're
because
obliged to
it is
respond to any
presumptuous.
question. It's not presumptuous.
It is presumptuous because it puts the cart before the horses.
I'm saying,
First of all,
I'm asking you, is it not possible if the Commissioner is not intending to reinstate General Mdluli, that you simply agree to the interdict stay in place?
No, that is
Why not?
presumptuous. Because it is presumptuous and it would be improper for me to even respond to that question. That puts the cart before the horses.
All right.
I've made very clear.
I've heard your submissions. I need to hear them. Take a seat. Mr.
No,
Mokhari.
no, I'm not finished with my
I'm telling
submission.
you, you are finished.
No, I'm not finished with my submission, my lord.
I'm telling you, you are finished.
No, I'm not
I
finished.
do not wish to hear you.
I'm entitled to.
I do not
I
recognize.
am entitled. my
You are
lord,
not entitled.
to make
I've heard you.
submissions. My lord, this
I
is
have heard your submissions.
no. This is a
You will
ground.
take a seat.
This is a ground for me to mention the second point that I mentioned to you in chambers. The second point that I mentioned to you in chambers was that
You will
if
take a seat.
no,
The court will adjourn.
They can. Let's go. Yeah, of course, let's go and see the guy.
Just because I'm not one.
He's not going to listen to us. Max Peugeot, yeah, that'll be fine.
Yeah, yeah. So I'll just. So I can be like this. Okay.
You want to? She told you this. Okay, you will hear the reviews. The latest indication will be better. That's why.
Was he
I wish to do the following on record. During the adjournment, I met with all the parties in the courtroom to discuss the issue that happened prior to the adjournment. And the directive that I'm going to give is a way forward in respect of this matter is that the matter is to be postponed in a year, mainly to give the National Commissioner an opportunity to file further papers in respect of other issues that were raised in the matter. Mr. Mdluli, presenting Mr. Mdluli, General Mdluli, stated that he also needs to consult with his client and to file further papers. So for that purpose, I give a directive that the matter be postponed in a year. I'll meet with the parties in about 2 weeks' time to give directives as to the timetable of filing further papers and both matters will be headed to. Briefly, this is what we discussed, unless if Counsel would like to add or correct anything that was dealt with in the vote. Mr. Mokhari?
Thank you, Manoj. We confirm what your Lordship has placed on record, that is what was discussed, and that we are in agreement with the directives that your Lordship is giving for the further conduct of this matter, and also the consolidation of the leave to appeal, as well as the application brought by freedom conduct. Mr. Court. Thank you.
Just two things. The first is your Lordship indicated in James that part of the directive would include that the order of Judge Murphy still stands in the interim to cater for the concerns that Freedom and the Law has about Mr. Mdluli being reinstated in the interim period. The other thing is that Freedom and the Law is inclined to bring an amended notice of motion setting out periods for answering papers to be filed. And we wonder whether your Lordship would have any objection to it.
Counsel, I do not give any directives regarding order of judgment, but ex-lege is the order of judgment. The application for leave to appeal has not yet been taken. And that is what is common cause between us. If you need to amend your papers, you can do so and sell them, as I've indicated earlier, to reach finality of this matter. I'm going to meet with the parties in about 2 weeks' time so that we can clearly discuss this aspect and decide on the date of hearing that will be suitable to all the parties.
Madam, if I may just here, to allay my little friend's concerns, because I understand what she said. At the moment, General Mdluli has not approached the National Commissioner that he wants to return to work, neither has he been invited to return to work. So that should allay her concern. And should anything happen, which then result in him assuming duties, then they will be able to still exercise their rights which are conferred to them in law. But that's what I can place on record.
I'm not going to make any ruling regarding that.
Indeed.
We'll discuss this better. There's a court order at the moment. The leave to appeal has not been entertained.
Indeed. So that should allay your concerns.
Any further comments?
My Lord, I act for the National Director of Public Prosecutions and the head of the Specialized Commercial Crime Crime Unit. We will abide by your Lordship's directives, not that we have any choice anyway. We remain of the view, but I understand your Lordship's position that they're separate matters, but we're not going to argue anything. We'll abide with whatever your Lordship's directives.
My Lord, thank you, my Lord. My Lord, we have already indicated, I've been informed that the advice that we are likely to give to our client is that we're taking issue with how that application has been brought about. And therefore, to the extent that Ms. Yakubu has said something about amending the papers, I'm sure it doesn't amount to this of condoning whatever and therefore giving a directive that papers should be amended. It's a matter that will still be dealt with. I just hope that one also remains clear.
Well, as to whether they want to amend their papers
Yes,
or not, it's within their...
Yes, we will deal with it. It's not like the court is saying, yes, do amend.
Any other thing that you wish to put on record before I adjourn? I've given directives in this matter and court adjourns.
News that moves. ENCA.com.